This case involves yet another Establishment Clause challenge to a monument displaying the Ten Commandments on public land. Traditionally, Establishment Clause claims are analyzed under the Lemon Test, which was established by the Supreme Court in 1971 in the case of Lemon versus Kurtzman. For government conduct to be constitutional, it must have a secular purpose, not have the primary effect of advancing or inhibiting religion, and not foster excessive government entanglement with religion. In 2005, the Supreme Court issued two Ten Commandment cases at the same time. The first case, Van Orden versus Perry, held that a 6-foot granite monument displaying the Ten Commandments on the grounds of the Texas state capitol was constitutional. The second case, McCreary County versus ACLU, held that framed copies of the Ten Commandments taken from the Bible in a Kentucky courthouse was unconstitutional. Here, the court agreed with the district court that the monument in this case was almost identical to that in Van Orden and therefore governed the result in this case. Both monuments were erected in the 50s as a result of a campaign by a Minnesota juvenile court judge. He believed if youths were exposed to one of mankind's earliest and long-lasting codes of conduct, they might be less inclined to break the law. In order to implement his plan, he obtained the help of the Fraternal Order of Eagles, a national civic organization. To allay concerns that the project may seem sectarian, he convened a committee of judges, lawyers, city officials, and clergy from several faiths to develop a version of the Ten Commandments which was not identifiable to any particular religious group. Through his program, around 150 monuments were distributed across the United States, including the one upheld in Texas and the one in this case. The court reiterated the nature of the Ten Commandments in some contexts as a secular moral message or as a historical message, and said it was clear that this case fell within the exception set forth in the Van Orden case. Just like Van Orden, the monument was designed to highlight the commandment's role in shaping civic morality in an effort to combat juvenile delinquency. Further, the setting of the monument suggested nothing of the sacred. It was placed with other monuments, and there was not a bench or area in front of the monument for prayers or religious gatherings. In fact, in this case, the monument was overgrown by several bushes. Just like the court in Van Orden, the court also pointed to the historic lack of complaints. The city had received only 7 letters from 2 citizens and 1 organization complaining about the monument. All these complaints didn't surface until the monument had been in place for 30 years. Reading the Supreme Court cases together, the court concluded that a limited exception to the Lemon Test exists in contexts closely analogous to those in Van Orden. And this was just such a case.